Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right, folks. We're back. We're back with the Truth Attack. Okay, let's get right into this because, again, I've got a number of stuff I want to try and get through, and we just haven't been able to do that for the last few weeks. I keep coming up short on time. So we are the Liberty Works Radio Network, and we do need the support of the members of the broadcast listening audience in order to keep the broadcast network operating. So if you enjoy the information, the shows, the discussions, the lectures, the revelations, and the guests and the hosts on the other shows on the network, we sure would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website. That's all one string, LibertyWorksRadioNetwork.com, and get signed up as a monthly subscribing member, even if it's as little as $10, $15, $20 a month. Every membership counts, and we do need your support to keep the broadcast network operating. And if you want to get fully informed on my favorite topic on this version of the Truth Attack Hour on Thursdays at 6 o'clock, you find your way over to the taxfreedom.com website, start reading and get educated. And if you know anyone that needs help answering the IRS correspondence or answering the DOJ in court, you send them over to irszoom.com where we can help you answer. Okay, so what do we got happening? Well, of course, after 47 years of war and terrorism in the Middle East sponsored by Iran, it appears as though the war is finally coming to an end, as Donald Trump has stepped up and decided to stop letting them wage war on America and our interests all over the world without consequences. Why do I say the war on terrorism is ending? Because Iran has been the sponsor and the funder of terrorism all over the Middle East. Hamas is an Iran terrorist-funded organization in Gaza. Hezbollah is an Iran-funded terrorist organization in Lebanon, Syria, Iraq. The Houthis are an Iran terrorist-funded organization that threatens the oil Straits of Hormuz, and oil passing through the Red Sea there. So these terrorist operations have all been of Iranian origin and Iranian funding. And Iran, of course, had the funding from the oil they were selling. And Trump has stepped up and shut that down. And you can bet those terrorist organizations are going to wither on the vine, because there isn't going to be any more Iranian money from oil to fund that stuff. Right now, they haven't destroyed the Iranian oil operations on Karg Island, which is the major export terminal in Iran, because they want to try and preserve the oil assets and resources so that a new government will have those funds and resources available to rebuild the nation of Iran. Trump knows you knocked that out and you're putting them back in the Stone Ages for a while. If you can preserve those assets, you could actually effect a clean transition from the Islamic regime to a civilian government that can fund its operations with a little bit of help, which of course they're going to be willing to provide to help keep those oil assets operating. And he's not going to deny completely oil to China or India. They're just not going to get the discount they've been getting from Iran for cheating the world's sanctions that have been put on them. So right now what's happening is they've pretty much wiped out all the targets in Iran. As I said last week, the Navy's gone, the Air Force gone, the air defense systems are gone. The only thing they've got left, it appears, is a mosquito fleet of small boats, which will be wiped out as soon as they try to do anything with them. And of course, the Iranian Republican Guard, which is the last piece of the puzzle that has to be targeted and removed in order to allow a civilian government to ascend to power. As long as the Republican Guard is there and in force and is able to come out and quell protests, and use military force to control the civilian population, it's going to be hard for the civilian population to actually put in place any sort of new government. So you're going to have to take out the Mosquito fleet, have the fifth, the Iranian small boats. You use the Fifth Fleet to escort the oil ships through the straits, and it should be all over quick because, of course, these small boats can't oppose the Fifth Fleet and its capabilities. And the A-10s in the air should make short work of it. The Republican Guard becomes an issue of how do you take out personnel, because you can't bring the tanks out without the A-10s, just wiping them off the map too. And who are you going to deploy the tanks against, right? So, this is, as Trump said, this is right on schedule. They're knocking out the assets. Iran has little ability to do anything. They've made a couple of strikes and killed a dozen people or so, but basically, in terms of war, this is already over. And it now becomes a matter of what tactics the U.S. wants to use to put in place that civilian government without destroying the nation's ability to do at least oil sales. Because, of course, that's the revenue source that Iran runs on. And as I said, Carg Island hasn't been hit yet. And it's going to come down to, if the civilians step up, it will stay in place. If they can't get a civilian government in place, they're going to take out Carg Island as they leave and decide we're giving up. So the Iranian population needs to do its part and take over the civilian government as these doors open. The U.S. has provided the help to allow them to be able to at least have a chance of acting. And as the Republican Guard comes under attack from the U.S. forces, civilians are going to have to step up, or the whole country is going to be sent back to the Stone Ages. And how are the Democrats reacting? Well, let's compare their reactions now to their reactions when Joe Biden said we have to support Ukraine in the war. And not a single Democrat said a word about the Ukrainian for 5 years. Now, after 8 days in Iran, they have a problem. Oh, isn't that sweet? Sorry, guys. You lost credibility and your voice when you didn't say anything about Ukraine, and just let it go on and on and on and on. You're now not credible. You don't get to criticize an operation that has been incredibly effective, both in Venezuela and in Iran. So they never said a word. They also never said a word about the rising price of oil caused by Biden's invasion of Ukraine. That didn't bother them a bit. They let oil be the lead inflation indicator and drive inflation to 9% in 2 years, and said nothing about affordability. Absolutely nothing. So again, you lost credibility and don't get to say anything now. And on the backside of that, I think that the price of oil that has occurred here, which you know I am against, the oil is your economy, but I think this is temporary. I think it will come back down. Both the U.S. and nations all over the planet are releasing reserves from their oil reserves. Now, when Biden did that, the Democrats didn't say a word. But now when Trump wants to do it with a real, actual cause to offset the rise, offset the price increase that's coming out of anticipated future problems, because none of this is real yet. They haven't disrupted the flows yet. Like I say, Carg Island is there. It's all the market reacting as it does with what it thinks may happen in the future. It builds it in. So now the Democrats are upset. Oh, now the price of oil. Now they want to talk about affordability. For 5 years, not one word. Not one word. 8 days into Iran, oh, the roof is falling, the roof is falling. Well, guess what, guys? Go home and let your roof fall in if that's what you think is happening. Nobody cares what you say anymore. Nobody cares. You've been in outer space for 5 years advocating for the destruction of the Republic and all of our moral boundaries. You've pushed division by race and religion, by wealth and productivity. It's just division, division, division. Nowhere do the Democrats work to unify the American people under a system of representation. They want to rule the rich so they can be robbed to buy the votes of the poor. It's absolutely nonsense. Absolutely. Okay, so let's go ahead and move on here. That's what I wanted to say about that. For the last few weeks, I have been reading from the petition that we are submitting to the Supreme Court. It's already there. It's docketed. This is case 25-6931 in the Supreme Court. You can pull it and read it. For the last few weeks while reading, I went back and reviewed the issues that are presented in this document. I'm not going to do that today because it keeps taking up too much time, but there are 10 issues we've been reading from it. We're halfway through issue 9, which I'm going to pick up on here. And if you want to read it, you can get it off the Supreme Court docket. Again, it's 25-6931. It raises all of the issues that DOJ and the courts have been using to cheat the American people in court out of a just finding in tax cases. And of course, as I pointed out a couple of weeks ago, that's being done through Chevron and regulatory deference, where the liability for tax is made up under a regulation where there is no liability laid in the statute that the regulation implements. So the regulation goes far beyond the statute to invent the direct liability that they invented fraudulently under the 16th Amendment. Of course, they had to do that because there is no statute that lays a direct liability because it's an indirect tax collected at the source and paid by the collector, as I have repeatedly explained. So when you claim it's a direct tax under the 16th Amendment, and you get to court and you're asked to show the liability for the tax, you can't do it because there is no direct liability in statute. So they had to make it up under the regulations for Section 1 and then claim regulatory deference under Chevron to force the courts to accept the invented liability under regulation that turns the indirect tax into a direct tax without constitutional authority and in violation of the prohibitions, the limitations imposed on all direct taxes. They also use that same regulatory deference in all substitute for return cases where they just make it up, a claim that you owe taxes without ever creating or performing a legal, lawful assessment on a tax return, which has to be subscribed in order to be in court, prima facie evidence good and sufficient for all legal purposes as evidence of tax owed. And without the tax return, subscribed tax return, sworn under a jurat, there is no evidence of any assessment of tax that is owed. And this is the method of operation within the IRS to cheat the American people under Section 1 and to cheat the American people under Section 6020B out of liability under Section 1 where there is none, and out of the requirement to produce a subscribed tax return under 6020B in order to have evidence of tax owed. Okay, I think I hear the first commercial break coming up, so we're going to get right into reading this when we get back. This is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour. We'll be back in 5 with more. Okay, this is Thomas Freed on the Liberty Works Radio Network. Let's just get right into this before I talk myself out of another segment. Okay, we're picking up in the middle of issue 9 with the Supreme Court petition to fix the federal income tax. Okay, I'm going to reread a couple of paragraphs from where we left off last week, just for continuity. The Circuit Court actually admits that the case record shows there was no Title 26 seizure that ever occurred. What we're arguing now is that count 3 under 7212, interfering with an IRS seizure, isn't satisfied by a civil action under 7403 because that's not an IRS seizure, that's filing a lawsuit. Filing a lawsuit is different from making a seizure under Title 26, which only occurs under 6331 as a levy, 6335 as a seizure. There aren't any other seizure statutes in Title 26 which have to be involved in order for this Section 7403 to apply. Okay, let's get into this. Because it writes on page 3 of its order that in May 2019, Gary Chapman, the IRS agent assigned, discovered that Cromar and his wife were still living there. He enlisted the help of law enforcement who removed the Cromars from the property on June 25, 2019. The admission by the Circuit Court that it was the public law enforcement resources of the state of Utah that removed the defendants and thus factually seized the home and property at that time is proof that there was no Title 26 seizure that occurred in this case sufficient to criminally charge the defendant under Section 7212B. Only an officer of the U.S. Treasury, the IRS, is authorized to conduct and make seizures of property under Title 26 law, and not the state of Utah's law enforcement personnel as admitted by the court. Citing IRC Section 7608, 6331, 6335, where 6331 is the levy, 6335 is the seizure, and 7608 is the authority of revenue agents to make seizures. And the foreclosure occurred not under authority of any Title 26 statute as required by the charging statute, Section 7212B, but only after Utah law enforcement authorities occupied the house under the foreclosure orders issued under Title 28 by the court. Chapman used that foreclosure order to persuade the local Utah law enforcement authorities to remove the defendants from the home and occupy it as part of the ordered Title 28 foreclosure. So no seizure ever occurs. Section 7403A provides that the Secretary may direct a civil action to be filed in a district court of the United States. This statute does not authorize a seizure to be made because a civil action is not a seizure, and no seizure may be made before the civil action is fully adjudicated, simply as a result of the civil action being authorized or filed. 7403, the statute says, action to enforce lien or to subject property to payment of tax. A, filing. In any case where there has been a refusal or neglect to pay any tax or to discharge any liability in respect thereof, whether or not levy has been made, the Attorney General or his delegate, at the request of the Secretary, may direct a civil action to be filed in a district court of the United States to enforce the lien of the United States under this title with respect to such tax or liability or to subject any property of whatever nature of the delinquent or in which he has any right, title, or interest to the payment of such tax or liability. So Section 7403C commands that the filed civil action then be adjudicated to a decree through a determination by the court on the merits of the claim before any further action, like a seizure, may be ordered or made. Clearly, Section 7403 itself does not authorize any seizure of property to be made. It only authorizes a civil action to be filed. The record in the district court is clear. No seizure of property ever occurred under authority of a Title 26 statute. Additionally, no property can be seized from American citizens to compel them to pay an assessment of a non-apportioned direct tax on their own income, because all direct taxes must be apportioned to the several states for payment more supra. That's the Supreme Court decision in 2024, more et Ux v. United States, where the court declared income taxes are indirect taxes. There's no enforcing a direct income tax on citizens. The whole system is a fraud. Okay, issue 10. This is the last issue we're arguing, and this has to do with whether or not the United States and the judges can order tax defendants to pay restitution in tax cases. Now, this is important. Everybody should listen up, because they're not authorized by the statute to get paid restitution. Issue 10. The United States is not a statutory person under Title 18, United States Code, Section 2510, that is eligible for restitution in a personal income tax case, and is not entitled to restitution from an individual for any direct tax on their own income. Under the Constitution, no individual can be compelled to pay restitution for a direct tax, because all direct taxes must be proportionately apportioned to the several states for payment more supra. This is the other thing the Supreme Court ruled in 2024 in more et Ux. They ruled that, not only did they rule that income taxes are indirect taxes, they ruled that all direct taxes must be apportioned to the states for payment in proportion to the census, no exceptions. And the government, the IRS, the DOJ, and the lower courts have been claiming that exception for 50 years. That's the constitutional fraud. There has never been an exception to the requirement to apportion direct taxes to the states, because any exception would constitute communism, which is what the courts have been enforcing on you fraudulently for 50 years, and the DOJ and the IRS. They're all enforcing the second plank of the Communist Manifesto. There's no legitimate constitutional taxation involved in this. It's not a tax system. It's a peonage debt service system, where all the money goes not to the Treasury, as required of all tax, but to the Federal Reserve Bank to service the $38 trillion and ever-growing, never-ending debt. It's not a tax system. Okay, but the trial record clearly shows that Cromar was convicted on the erroneously alleged basis of an unlimited direct tax on his income, as declared by the trial court in taking jurisdiction under Collins and Belize. Those are the two cases the court claimed jurisdiction under to tax directly and without limitation, and with no enabling enforcement clause to authorize Congress to write law. So, the legal authority of the district court to order restitution should be a matter of strict statutory construction. Section 3563b2 provides that a defendant can be ordered to make restitution to a victim of the offense under Section 3556 as part of a sentence under authority of Section 3556, which in turn provides that restitution can be ordered under authority of Sections 3663a or 3663. Those statutes provide that the defendant make restitution to the victim of his offense, and that for the purposes of this section, the term victim means a person harmed as a result of the commission of an offense. the term person is defined in law for use within Title 18 at Section 2510(6), which provides that 6, person means any employee or agent of the United States or any state or political subdivision thereof, and any individual, partnership, association, joint stock company, trust, or corporation. End of definition. The applicable definition of the term person under Title 18, who is eligible for restitution as a victim, does not include the United States as a person, only its employees and agents as individuals. The United States is not a person eligible for restitution. This is all fraud too. The United States is excluded from the statutorily defined person who is eligible for restitution. And the U.S. Department of Justice Criminal Resource Manual, CRM 1000-1499, provides the term person is defined in 18 U.S.C. 2510(6) to mean any individual person as well as natural and legal entities. It specifically includes United States and state agents. According to the legislative history, only the governmental units themselves are excluded. The government entities themselves are excluded from the Title 18 definition of the term person who is eligible for restitution. The government isn't a person eligible for restitution who is a person, an individual who was harmed by the offense. Under the Title 18 statutes, the term person excludes the governmental units themselves. That means that the United States is not a statutorily defined person who can be a victim that is eligible to receive restitution as a function of sentencing a convicted defendant. Okay. Additionally, the United States DOJ provides in a public statement that some financial losses are not eligible for restitution, such as state or federal taxes, interest, penalties, or fines. The United States is not entitled to restitution from individuals for direct taxes, interest, penalties, or fines, because there is no direct tax that is constitutionally authorized, and there has been no loss of real property or injury that has accrued to the plaintiff. It's a civil dispute over money. There's no loss or injury. Thus, it was beyond the subject matter jurisdiction of the district court to order that restitution be paid to the United States by the individual defendant to enforce the payment of the direct tax without limitation that he was allegedly convicted of by a court that didn't have the subject matter jurisdiction to conduct that trial. The whole thing was a fraud. Every trial is a fraud from beginning to end and has been since 1955. Every single trial, every single civil complaint, every single lien, every single levy, it's all criminal fraud being perpetrated by the IRS to impose the socialist enforcement of a communistic income tax that allows the government to rule the people by robbing them and arbitrarily and capriciously attacking them whenever it wants, using a code that's so convoluted and complex nobody knows what's in it, not even the judges. Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and let's just go ahead and get right back into this. I think we can actually finish this up today. We're up to the last section. We've been through the 10 issues that we're raising and are using to build our case step by step to prove that the tax is an indirect tax, not a direct tax, to prove that the enforcement of the tax as a direct tax without limitation is also unconstitutional, and that because they're claiming it's a direct tax, the court lacks the subject matter jurisdiction to conduct these cases, both civil and criminal. It's 75 years of the courts acting without subject matter jurisdiction. The fraud is monumental. And it's all been irrefutably exposed by the Supreme Court in Moore et al., which is on the taxfreedom.com website. So you probably want to head on over there and start reading. Okay, let's get back into this. Reasons for granting the writ. Therefore, due to the constitutional and statutory foundations of this appeal, addressing the fatal lack of a granted subject matter jurisdiction of the federal courts to enforce, under alleged authority of the 16th Amendment, the criminal charges that were based on the defendant's alleged attempt to evade or defeat a tax assessed by the United States, IRS, as a direct and unlimited tax on income that is unavoidably enforced against individuals without an indirect basis for the taxation of their domestic activities and transactions, and based on the fatal lack of any evidenced statutory liability for tax, which was never assessed on a subscribed prima facie tax return as the only admissible best evidence allowed under Section 6020B2. And because no Title 26 seizure factually occurred under any Title 26 statute, and because the United States is not entitled to restitution from an individual for a direct tax. Petitioner respectfully urges this honorable court to grant this petition. Defendant appellant cannot be guilty of attempting to evade or defeat a non-apportioned direct tax on his own income, which tax must be apportioned to the several states for payment, and which direct tax cannot be constitutionally enforced against his individual person, more supra. Respectfully, his conviction should be overturned or reviewed de novo of the entire case record should be initiated. It was the duty of the circuit court to review the factual record at trial. And it was not their duty to simply try to justify the trial result with arguments that are not supported by the statutes or the record of evidenced facts and rulings made in the case. Nor may the conviction be justified and sustained under the superseded opinions and judicial legislation wrongfully invoked and utilized to manipulate the statutes in order to convict the defendant in the district court and sustain the conviction on appeal in the 10th Circuit. Therefore, because material facts have been ignored and statutes misapplied and provisions of the Constitution have been violated, and since the opinions relied on conflict with the most recent applicable and controlling decisions of this Supreme Court, which conflict was not addressed in the lower courts, and because one or more questions of exceptional constitutional and national importance are involved in this case, this honorable court is respectfully urged to grant this petition for a writ of certiorari and take up a review of these matters de novo based on the record of the district court at trial, the specific language of the applicable statutes, and the consistent decisions of this court reaffirmed in Moore regarding all lawful and authorized federal taxation under the U.S. Constitution, which is clearly being violated in this case by the plaintiff United States and the lower courts. Prayer for relief. Petitioner now prays this honorable Supreme Court will either overturn his wrongful conviction or take up a review de novo of all of the issues of 1, the subject matter jurisdiction of the federal courts that can be taken over income tax trials of individual citizens. 2, the case record of facts at trial. 3, the controlling statutes and their proper application. And 4, the erroneous holdings of the lower courts that were made in this case and wrongfully and prejudicially relied upon to first convict the defendant and second to sustain that conviction on appeal in the 10th Circuit. Respectfully submitted. So, there you go. Now, we also submitted a number of appendices. Why don't I run through these? These are a part of the record in the court. They can be seen there. Appendix 0 was the 10th Circuit order and judgment being appealed. Appendix 00 was judgment in a criminal case in the Utah District Court. Appendix 1 was Moore et al. v. United States, the excerpt that lays out the holdings of the Supreme Court that income taxes are indirect taxes under Article 1, Section 8, Clause 1, not a direct tax under the 16th Amendment, and that all direct taxes still had to be apportioned to the states for payment in proportion to the census. Appendix 2 is the IRS DOJ's frivolous arguments document excerpt exposing where the courts have all been holding in the various circuit courts since 1980 that the income tax is a direct tax under the 16th Amendment without limitation, non-apportioned direct tax. It's in the IRS's frivolous position paper. They can't deny that's what they've been doing. They can't deny it. It's what they have been arguing, both the IRS and the DOJ. It's what the lower courts have been holding. It's all laid out in that frivolous positions paper. And now all of it, under Moore, exposes the fact the circuit courts were lying to you. They're enforcing liberal communism, their own political philosophy, not any form of constitutional taxation. Appendix 3 was IRS Revenue Ruling 2005-59, stating that the Form 4549 examination worksheets that are substituted for actual tax returns, well, Revenue Ruling 2005-59 says those worksheets are not tax returns. This has already been decided by the courts. Those aren't tax returns, but the courts accept them as tax returns in civil and criminal prosecutions. They've been ruled they're not tax returns. How do you substitute a worksheet for a prima facie evidence of a subscribed tax return under the statute? And the statute is not only 6020, but 6201, which says the assessment of taxes occurs based on returns or unpaid taxes payable by stamp. Now, everybody knows that income taxes aren't payable by stamp, so it has to be shown on a return in order to be an assessment. Appendix 4 is the letter from the GAO admitting that no tax returns are prepared in the IRS SFR program, which is what was testified to in the year 2000 in Capitol Hill hearings. They admitted no SFRs are created. We just make it up. We just make it up. And nobody paid attention, apparently, except for me. Appendix 5 are the statutes referenced throughout the brief. Appendix 6 is the DOJ's statements that there's no restitution for the United States or for unpaid tax unless it was stolen tax money, like an ATF store that collected tax and then kept it and didn't send it in. That's actual theft for which restitution can be made. But coming along and saying you owe us $100,000, that's a civil dispute. There's no loss, and there's no restitution allowed. Appendix 7 were the supporting precedents, all the other opinions that support the lack of jurisdiction, the consequences of a court that acts without jurisdiction, and etc. And in Appendix 8 are all of the statutes in Title 26 which do make a person liable for tax, which proves or shows that none of them apply to income tax or to American citizens. The only statutes that make a person liable for payment of the income tax are 1461, which makes withholding agents liable for the tax they collected from foreign persons, where the tax is paid by the collector, not the wage earner, and Section 3403, which is also a statute that makes the employer liable as the collector. He's responsible only for what he has collected from his employees, which collection all occurs by allowance. So those are the statutes that make parties liable for the federal income tax. They only go to the liability of the tax collectors because it's an indirect tax. There is no liability in the law for the payment of the tax by the wage earner. Again, that's made up under regulatory deference under Chevron for Section 1, which imposes a tax on taxable income in the statutes and says absolutely nothing about who's liable for this tax on taxable income. Of course, later on, there's another statute that says, oh yeah, that tax on taxable income, it's collected by withholding agents from foreign persons. And there's another statute that says, oh yeah, you know that tax that was collected from foreigners by withholding agents? Well, those tax collectors are liable for the payment of the tax. The same way a store is made liable for the payment of the tax it collects. And again, where the collector pays no tax out of his own pocket, or on his own business, or on his own income. He only turns over what he's collected from others, and there's shifting of the burden from the payer of the tax, the collector, to the pocket of some other person, i.e. from whom the tax was collected, keeps it all indirect. Keeps it all indirect. That's why they had to make up the direct liability under regulation. It isn't there in the statute because it's not a direct tax. It's indirect, collected at the source, which was declared by the Supreme Court in Bruchaber in 1916. It was never declared to be constitutional because it was a direct tax. It was constitutional because it's not a direct tax. And that's the way it stayed and was enforced until 1942 in the victory tax, which can be argued to have been a form of an income tax because it was imposed on the earnings of all persons. But that was the first time the labor of the American people were touched by tax. That was a temporary 2-year war revenue measure that expired in 1944, and there's been no new tax imposed ever since. And the tax imposed in 1913 wasn't imposed on you or on the citizens' activity in the 50 states, only on foreigners in the 50 states and on all persons in the territories and possessions and in foreign countries under tax treaties, which is where Section 61 originated 5 years later in 1918 under a Canadian tax treaty that expired in 1993, making Section 61 dead letter law for over 30 years. When original legislation expires, so too do all the statutes enacted under it that weren't reenacted in the interim by Congress with a greater applicability at law than they had under the original act. And Section 61 was never enacted with further authority than it had originally under a Canadian tax treaty that didn't reach your activity in the 50 states. There's no basis for taxing your interest, your rent, your dividends, your annuities, your wages, your salary, your compensation. None of that exists. It's not federally taxable activity or transaction. Okay, I think I hear the end of the show coming up. This is Thomas Freed on the Liberty Works Radio Network. Help spread the word. Tell your friends, neighbors, relatives, and business associates to listen in. Find your way over to taxfreedom.com. Get educated, and irszoom.com to get help. This is Thomas Freed on the Liberty Works Radio Network. I'll be back next week with more on more, no doubt.